Good day, students. I hope you're keeping well under this corona pandemic. My name is Ms. Milka Kithinji. I'm going to be taking you through our usual unit of international trade law, but today we are looking at payments in international trade, and we are also going to specifically look at documentary credits. So welcome to class. The last class we had, we were looking at Incoterms, and we agreed, or we had a summary that Incoterms are very key to understand the seller's and the buyer's responsibility in terms of who is responsible for transporting goods, and in terms of risks, in terms of costs, so that the parties can agree and we can reduce litigation thereafter. Okay? Now, having settled on that, what is payment? Payment is defined as a performance of a duty, promise or obligation, or a discharge of a debt or liability of money of other value. So when we are looking at payment, it is that kind of exchange for a good, you have already settled between the parties, the buyer and the seller, that now you have an obligation. And now you need to settle that obligation, whether you're the one receiving the goods or you're the one producing the goods. So on both sides, there's payment in terms of, if it is a seller, he has to pay to produce the goods, he has to pay to package them, he has to pay for whatever else he needs to do to make sure the goods are ready for transportation. Whereas for the buyer, he has to prepare the payment for the total cost of those goods. So in that sense, you have to be ready as a party in that agreement. Okay? Now, the UNCTAD, the United Nations Conference on Trade and Development, defines payment as payment as a clean remittance which is made after accepting the order, but before the shipment through a banking channel. So there are a number of issues that we see here, that there's a remittance that would be made after accepting the order. We are saying that the buyer has placed an order, the seller has agreed to provide those goods, therefore there's already an agreement. So in essence, we're talking about that there's a sales agreement in place. Then thereafter, we are saying the seller then prepares these goods subject to what you have agreed, the terms of the contract. Then he puts them together, ready for shipment, awaiting the payment of the buyer. Okay? Then we have that kind of payment, the one that UNCTAD is talking about. It is the simplest and it is the least in terms of risks, because what is going to happen is that the seller is assured that they are going to have their payment before they release the goods. However, in terms of risk, the risk is on the buyer's side or the purchaser's side, because they are releasing funds, okay, before they see the goods. However, the comforting thing is that they are doing this through a channel, which is the bank. Now, when they involve the bank is a third party, and we are going to see how the bank enables both parties to have an easier time in terms of allaying their fears as regards payment. Okay? Now, there are a number of payments before we get to the documentary kind of credit that we want to look at today. There's an open account where the exporter and importer agree upon the sale terms without documents calling for payment. So we just agree. We say, I'm going to sell you this amount of goods, and the buyer says it's okay, and they don't have to document it. So an invoice is prepared by the exporter, and the importer can take the delivery of goods without making the first payment. Okay? The exporting and importing firms settle their accounts through periodic remittance. In that kind of sense, when you're talking about an open account, it means then that the parties have been trading for a long time. There's a sense of trust between them. Then what we want to know as the major challenge with the open account is that there's a lack of safeguard measures against non-payments by the importer. So even if they have been trading for a long time, if we can use the example of the coronavirus now, where we're saying we have been trading, we have this trust. I have been importing vehicles from Tokyo, and the seller has been sending the vehicles, and it has been an open account in the sense we have not involved the bank, but we agree on how we are going to pay. So given the stringent measures that have been placed by different governments, the vehicles are late. And by the time they reach or they arrive in Kenya, then the importer changes his mind, or they are not as liquid as they thought they would be, and they are unable to meet the obligation. In that sense, then you find that this open account is, that would be the greatest challenge in terms of there is no guarantee that you're going to get payment. The next one is consignment sale. When you're talking about consignment sale, the exporter allows a shipment of goods to be made to the consignee, but retains the title of goods until they are finally sold. Is that clear? He maintains, the consignee retains the title of the goods until they are sold. Since the title of good lies in the exporter, the funds are blocked and the payment period is uncertain. Okay? Now, we also need to know that there's an additional cost such as warehousing charges, insurance, interest, commission on the good, commission of the agent, sorry, and there's also a liability and risk which lie with the exporter unless the consignment is sold. Okay? So I think that is very clear. Under consignment sale, the consignment is kept, it is held until it is sold. Okay? And the title remains with the exporter. The next one, what I could summarize is that this mode of payment is restricted to dealing with trusted counterparts in the overseas market. So we can also see that in terms of trade, we always have to have trust. We always have to understand each other. There has to be a relationship that has been established over time. The next form of payment is bill of exchange. A bill of exchange is a written instrument which contains an unconditional order where the drawer directs the drawee to part a definite sum of money, okay, to the payee or to his order, okay. It is payable on demand or at a defined time, and is signed by the drawer, and it is dated. I think we understand this in terms of when we're looking at our previous classes on contract law. A bill of exchange, as defined, would need a number of things. One, the amount of money has to be very clear in terms of what would be the sum payable, and it is a fixed sum. So even if there has been a scourge like the one we are undergoing of corona, we cannot change that money. I mean the sum. It has to be fixed, and it binds. You cannot demand that money from somebody else or another party. It has to be the party who is explicitly written in the document and at that specific date. Secondly, the parties involved. So when you talk about a bill of exchange, it can be between individuals and banks. It can be, and then it is usually transferable by endorsement. So if you endorse it to give it to somebody else or to another third party, then the party whom has been specified in the bill of exchange is the one who is going to receive the money agreed upon by the drawee. And the drawer, the party that obliges the drawee to pay the payee. I hope that is very clear. The drawer and the payee are the same entities. They are what? The same entities at all times. And unless the drawer transfers the bill of exchange to the third party payee, then only the person who is explicitly provided or written in that bill of exchange is one who's going to receive payment. Then we have the date as a third requirement. A bill of exchange orders a debtor to pay at a particular date. That date is very key in terms of payment. Finally, we get the documentary credit. So those are different forms. What we have addressed are different forms of payment. But today we want to look at the documentary credit because it is what is mostly used in international trade agreements. And it is very key because many organizations, banks, individuals trust this kind of document in terms of facilitation of international trade. So what is a documentary credit? It's a commitment by the bank on behalf of a buyer. that payment will be made to the exporter provided that the terms and conditions stated in the letters of credit have been met and verified through presentation of all documents. Okay? There's a bank involved. Remember, when we're talking about open account, bill of exchange, consignment sale, the bank is not involved. But under documentary credit, we introduce the bank. And the bank is saying or guaranteeing that they are going to pay a certain sum on behalf of the buyer. Okay? And that payment will be made to the exporter, provided that the terms and the conditions of the sale agreement have been reflected in the letter of credit, okay, and have been met and verified through the documents that have been presented to the bank, okay. Now, it is a written undertaking by a bank, and the bank in this sense, the one that is acting on behalf of the buyer, is called the issuing bank, and it is given to the seller, who is the beneficiary in this sense, at the request and instruction of the issuer, who is the buyer, okay, to pay at sight or at a future determinable date up to a stated sum of money within a prescribed time limit and stipulated documents, okay. Now, this regime that governs this kind of documents is found under the Uniform Customs and Practice on documentary credit. The first time they were the document, the legal instrument that was enabling parties to actually trade was formed in 1933 by the Commission on Banking Technique and Practice, or in the International Chamber of Commerce at Vienna. It has had a number of revisions. The latest version is UCP 600, which came into effect in July 2007. For purposes of this class, we're going to use UCP 500, and it has been adopted by the banking system in 160 countries, and we are still counting more countries, and it is known as the most important rule for governing documentary letters of credit, okay. So and the UCP governs all kind of international trade globally. So if we can go on, another development that has happened after 2007 is that they also developed the EUCP, the electronic UCP, okay, which enables parties to send documents electronically. Previously, what would happen was that once you'd fill in the forms would be shipped through post office, and the buyer would have to wait for those documents, and then present the documents to the bank. Now, we are talking about a situation where once the seller finishes preparing all the documents, all he needs to do is scan and send them. Once he does that, then he is able to the buyer is able to get the documents, print them, and present them to the bank for the bank to act upon them in terms of preparing payment for the seller. Okay? Now, why is the bank so important? It is because the bank has the operational expertise in terms of handling issuance and presentation under letters of credit. They have the tradition of independence from underlying transactions, which is the basis of commercial reputation of the letter of credit. And the third thing is that banks are often regulated with a view toward protecting those who rely on their undertakings. Are we saying then we cannot have an individual providing an undertaking? Not at all. It is just that if you compare an individual and a bank, we would rather go with the bank because of the regulations that are in place, the fact that you can trace the documents, the fact that it is common practice not just in your country but in many other countries, 160 countries. Okay? So how does the bank cover for the risk? In order for the bank to cover for the risk, the bank will usually request for guarantees from the importer, such as blocking an amount equivalent to the sum of the documentary credit, okay, on a special account in order to guarantee that the account has sufficient funds, okay, on the anticipated payment date. Then it could also ask for the parent company or the partners or the shareholders to act as sureties on behalf of the buyer. And then also it would ask for moral guarantees, okay, so that the bank would carry out due diligence to ensure that in the event that you as a buyer or the buyer goes insolvent, they did not commit blindly. Is that they had the money, they knew who would act as a surety, somebody else would stand in for the buyer in the event they die or they become insolvent, and they also want to know how has this buyer been handling their credit. Do they pay their debts or not? So that on that basis, then they would issue what? The letter of undertaking to the advising or the confirming bank. Okay? Now, what are the nature of the functions of the documentary letters of credit? It guarantees payment to the seller. That is one. Two, the seller can use the credit to raise independent financing for that trade. Three, it reduces commercial risks for both the importer and the exporter. Okay, by providing security of payment for the exporter and security against non-delivery for the importer. Then it provides finance for importers and helps them with cash flow. Then it is used as a conditional payment method and providing the possibility for the seller to receive payment from the importer in case the credit has been dishonored by the bank. Then it is used to discharge legal obligations for payment from the buyer by having the bank pay the seller directly. Okay? So in the event the buyer is unable to make payment on the purchase, the seller will make a demand for payment from the bank. You see, in all aspects, at all times, the seller and the buyer are protected. Now, we have a number of letters of credit. The first one is revocable. It's found under Article 8 of the UCP 500, and it is a credit is said to be revocable when it may be amended or cancelled by the issuing bank at any moment and without prior notice to the beneficiary. It can be amended or cancelled at any moment prior without any notice. The bank can just cancel it. Now, you see, the issuing bank has been instructed by the buyer. And when it guarantees payment upon presentation of proper documents. Remember, we had the sale agreement. The sale agreement is the one that has been taken to the bank to prepare what? A letter of credit. Now, if the documents that have been presented are in the correct form in accordance with the sale agreement, then they would pay. But if a site credit is involved, the bank may not revoke the credit after payment or make changes affecting the payment. It is important. The important factor is not the time of the document's delivery, but whether the payment has been made. Okay? Now, in the case of a deferred payment, for instance, the buyer had given instruction, pay the seller on the 31st of March. Then, because of the coronavirus, the buyer communicates to the seller and also communicates to the issuing bank and tells them, kindly defer the payment till the 15th of April when I hope to have enough funds. In the case of deferred payment, the issuing bank cannot amend its latter payment commitment once a document has been taken up. Okay? Once the bank has examined the documents and found them to be correct, it has to pay. Okay? So what the challenge that we'd have in this kind of payment, of this revocable letter of credit, is that it provides no security and therefore it is prohibited. So there is no security in terms of the buyer, because once it is in terms of the seller, my apologies, in terms of the seller, in the sense that once you prepare that document and the buyer changes their mind, it will simply be cancelled or be amended. Now, can you imagine, you as a seller, you had taken a loan on the other end, and all of a sudden the document has been amended and the time frame when you're supposed to receive money has also been changed. In essence, you'd be incurring more costs, unlike because of that kind of change. So the revocable letter of credit is usually not recommended. Now, what about an irrevocable letter of credit? Under Article 9A of the UCP, it is said when it is an irrevocable letter of credit when the issuing bank gives a binding undertaking to the beneficiary that it will pay against documents or bills that are drawn in compliance with the terms of the credit. In that sense, once the buyer has given instructions to the bank to open an irrevocable credit, the buyer is powerless to prevent payment being made. In the instance where we are, if you had taken an irrevocable letter of credit and we are under the coronavirus as we are now, essentially what we are saying is that if your goods had not been received and the Kenyan government has closed the port, the bank will be forced or is obligated to pay for the goods, whether they are at the port or not. Okay? The case of Stein versus Ambrose Bank, the judge Rowlatt stated that the obligation of the bank is absolute and is meant to be absolute, that when the documents have been presented, they have to accept the bill. That is the commercial meaning of it. Okay? Now, if we go on, Article 9B would define the confirmation of an irrevocable credit by another bank upon authorization or request of the issuing bank to constitute a definitive undertaking of the confirming bank in addition to that of the issuing bank, provided that the stipulated documents are presented to the confirming bank and the terms and conditions of the credit have been complied with. Okay? Now, let's look at transferable and untransferable credit. The main purpose of making an irrevocable credit transferable to a third party is to enable the beneficiary to acquire and pay for the contract goods which he cannot supply himself and may have to get them elsewhere. Remember, the beneficiary is the seller. So if he gets an order of 10 billion and he cannot raise that sum of money, the transferable letter of credit would enable him to sell that letter of credit to somebody else to receive the funding that he needs so that he can provide the goods. Article 48 of the UCP would define what a transferable credit would be. Article 48B would describe this type of credit to be one that can only be transferred once unless otherwise agreed. So if you transfer it to person A, the third party A, the third party cannot transfer it to somebody else. Okay? Now, the converse would also mean that if it's not transferable, it would be explicit in terms of when it would be drafted. Now, what is a straight credit? It is issued, it's a letter of credit by which, when issued by the issuing bank, the confirming bank, if applicable, provides the undertaking to the named seller only, and only he may rely on it. That's a straight credit. So meaning that once you have put the name of the person who is going to rely on that credit, you cannot change it, you cannot amend it. Okay? A negotiable credit is where the seller obtains the negotiable credit, then the issuing bank will give it to the person to the order of somebody else. It doesn't have to be explicit that the person who is, there's no name actually put, it's just given to an order of a certain bank, and that person is the one who's going to pick. The person who appears with the documents is the one who's going to be given the goods in that sense. So if, in essence, what we are simply saying is that when you are looking at these letters of credit, you need to look at them carefully and understand what are the terms. Is it negotiable? Is it non-negotiable? Can you transfer it? Can you not transfer it? Is it revocable or is it irrevocable? So that you can advise your clients, whoever will come to you, what is the best way forward so that you can secure their interests. Thank you and stay safe.
These televised lectures supplement our robust online learning going on our MKU online platform. You can view more on our televised lectures via our online platform. We are in a digital era, and Mount Kenya University knows this. The following are the steps to follow so as to complete your online application. Download the application form from the website www.mku.ac.ke. Attach copies of your academic certificates and ID. Pay the application fees via M-Pesa pay bill number 270988. Your ID is the account number. 2,000 shillings is the charge for a postgraduate. You can also deposit in the bank accounts provided on the website. Then email all the above to apply@mku.ac.ke. Exciting world of M-Truck Solutions, your trusted provider for bulk SMSs. We also offer API integrations for all your communication and payment needs. We also provide you with